Joining me in studio this hour, national trial attorney Michael Jaafar. Michael, I don't think it's surprising, 2 hours, 23 minutes in, 2 questions the jury had asked. They wanted to listen to those 911 calls. They wanted to know how the door was damaged. I think they looked at all the details. And what do you think of their verdict?
I think their verdict was proper. I think this jury did their homework. When they came back with those questions, I knew that what they were trying to do. They wanted to recreate the scene of the crime, but not just the scene of the crime, what a reasonably prudent person would believe at the time if they were in the same situation as her. The only way they could do it, the only way they could dig into her state of mind was to look at anything that was close to the scene of the incident. The 911 call, interrogations after, the calls before, all important, but not anything compared to the damage to the door and to the 911 calls after. Why is it important? Because you want to know what would a reasonably prudent person have felt, not done, felt at the time. Because under Florida law, you cannot use deadly force unless you have an imminent fear that someone is going to use deadly force against you, right? You can use regular force, not deadly force. Deadly force is reserved in Florida only if you feel that you are an imminent threat for deadly force. So how would the jury know this? They have to look at her 911 calls and the damage to the door. I'm sure if A.J. Owens was trying to break that door down with a battering ram, they would have came back different. But she had her hands and she was knocking on the door and she got shot. In Florida, you can't do it. She was still outside of her domicile, outside of her house in the castle doctrine. So I think the jury did the right job and they did their homework. They didn't come back in 10 minutes and say guilty.
Right.
You know?
Right. They looked at it again. They made sure they decided. It was a jury of 6. We know that's an option in the state of Florida. This was 6 individuals, unanimous decision. You know, and I just want to go through quickly the manslaughter definition in the state of Georgia. An intentional act, they determined it was, in Florida, that was neither excusable, which it was not, nor justified, and that it resulted in death. So they found it was not justified, it was not excusable. Now I want to juxtapose that with really quickly listening to this defendant, now convicted of first-degree manslaughter, but to this defendant telling the police during her interrogation that, hey, I feared for my life. Let's listen together.
I really feared for my life. I mean, honest to God, I was like, I'm a nervous wreck. You know, I'm not supposed to be getting nervous or anything like this because I have an aneurysm on my left kidney artery. And so they're like, just, you're supposed to stay calm, you're not supposed to do anything. And this woman just keeps antagonizing me. She's got the kids calling me. I'm a doctoral degree. Do not talk to me like I am one of your peers.
All right, so there we heard her saying she feared for her life. But I guess, Michael, the jury must not have believed her on that video. She didn't testify. They did see that interrogation video. They must not have believed what she was saying.
One of the jurors must have said, hey, listen, she has had a bunch of self-serving statements after the fact. I don't think a juror would have believed that she opened up Chapter 776 of the Florida Penal Code and researched, you know, what justification would have happened. But I know that the debate in that jury room would have centered around whether or not she feared for her life or whether a reasonably prudent person would have feared for her life. We know that her defense attorneys brought in evidence that, you know, her friend was raped and bound and all these things, right? They wanted to recreate in the jury's mind, hey, this person would have thought something different than somebody else. Also, her door had previously been broken down. They did a fantastic job.
They did.
Yeah, they did a fantastic job. This is another, I don't know what's going on in the state of Florida, Judge Jesse. They're turning out cases that are going to be taught in law schools. This is a case that a law professor would have to teach his kids because it could have really gone either way. If the jury would have came back and acquitted her, I wouldn't have been surprised.
I agree with you. It could have gone either way. And again, it was her state of mind. Would a reasonable person have been in fear for their life? Let's listen also to the description of Owens, the victim in this case, who is unfortunately deceased as a result of this gunshot wound, and what was said about her trying to get inside of that door the defendant shot through.
So AJ, she came to your door.
Oh yeah.
And she was
pounding on it. Like I was like, what the hell? My cat's going to fling.
What was she saying? What, was she saying
like,
anything?
You don't talk to my sons. I'm gonna kill you. I'm gonna kill you. I'm like, oh, you know. And I was like in tears. I'm like shaking, and I'm like, oh my God. And I thought she had gone away, and then she starts banging again. I'm like, oh.
Did she like try to come inside?
She was trying as hard as she could.
And what do you mean?
That door was, that door was moving. And I'm like, holy you know.
Like, did she try the door handle, or was she just beating on it to try to push it in, or what?
She was just, just trying to push it in, trying to push it in. And I was like, oh my God.
So what was she saying again?
She's like, you can't talk to my sons that way. I'm like, you're trespassing,
So you were communicating with her through the door?
Yeah, I'm like, all right, just leave. I don't want to hear it. Now I'm going to kill you. I'm going to kill you. And I didn't think too much of it until she really started pounding that door. And I'm like, oh my God. Then I got scared, like terrified, scared.
Pounding on the door, terrified, scared. Again, the jury did not believe her at the end of the day, but rather believed that she intentionally shot through the door and it was not excusable. It was not justified. How does it feel when you're representing someone standing there? She's facing up to 30 years.
Yeah.
That is a lot of life, arguably the rest of her life. Yeah. How does that feel waiting on that verdict?
This is the most jarring moment. I mean, even when I was a public defender and I'd have, 10 clients a day, right? And when we would try 3-4 cases a week, even as something as small as a misdemeanor, right? Even on bench trials, you would it was nerve-wracking. That's a difficult place to be for any defense attorney and any defendant. Any defendant that ever sat next to me was trembling when the jury came. They were trembling. This is the most anxious moments. And honestly, Judge Ashton, when I see these videos, I feel like I know I'm looking ahead, but I don't think this woman's going to get sentenced to the max. I mean, this case was so close. It was so down the middle that I feel like she had a convincing case to be afraid. I think she went over the line, shooting a gun through the door. But at the end of the day, the jury, they were there, they saw it, and they did their homework. They didn't come back in 10 minutes. They did their homework. I liked it. I trust their wisdom on this case.
Yeah, and I agree with you. They did their homework. I just have to mention that without the firearm, she would have had second-degree manslaughter facing 15 years. That firearm makes it a first-degree felony and faces 30 years. So maybe she gets closer to 15 years. We don't know what's going to happen at sentencing. But to your point, we're going to have to wait and see on